council to submit electronic files of any potential exhibits in advance. Hopefully you've done that. But even if they have been submitted in advance, all exhibits must be offered and admitted into evidence to be made part of the record. Any proposed state party wishing to present testimony needs to be sworn in and subject to cross-examination. We have our wonderful court reporter present, and she will make the official record of today's proceedings. We will also record today's proceedings for posting to our website. Any other recording is prohibited. Today's proceeding is being live streamed to our YouTube channel. So with the housekeeping out of the way, let's call today's docket. We have one matter before us today. I'll call case number 67709 in the matter of Paul Jason Brower, which is a petition for revocation of probation. Is the commission ready to proceed, Mr. Berry?
We are.
What is your time estimate?
Probably no more than 15 minutes. I have one witness.
Thank you. I don't believe we've heard from the respondent or anyone representing the respondent. Is the respondent present on the call? Ms. Pruitt, is the respondent in the waiting room?
He is not.
Mr. Berry, I believe you said it right before we got started that you have not heard anything from Mr. Brower. Is that correct?
That's correct. We have not.
Okay. We've previously communicated with Mr. Brower and received an email from him on April 28th, 2023, that he would be available for today's hearing, and it was our understanding he intended to participate today. We'll go ahead and proceed. We gave him a 5-minute grace period to see if he was running late, but still haven't heard anything. So let's just move forward. And Ms. Truitt, if you get any message or hear anything from Mr. Brower, would you let us know?
Absolutely.
All right. Thank you. I'll call case number 67709 in the matter of Paul Jason Brower. Mr. Berry, would you please state your appearance for the record?
Judith Berry, appearing on behalf of the Commission for Lawyer Discipline.
Thank you. And would you like to make a brief opening statement, or do you want to just launch into your presentation?
I'll just launch into the whole thing.
All right. Very well. You may proceed.
Okay, thank you. This is a revocation probation proceeding under Part 2.22 of the Texas Disciplinary Rules of Disciplinary Procedure, seeking to revoke a judgment in case number 2019-01592, an agreed judgment of partially probated suspension entered on October the 6th, 2020. The petition for revocation of probation was filed with the board on March the 29th, 2023, and the respondent was served on April the 12th, 2023, via personal service by Nathan Willingham, a private process server. The original proof of service was filed on April the 21st, 2023. The respondent violated the terms of the judgment by failing to comply with the following terms. First, he failed to pay reasonable and necessary attorney's fees in the amount of $300 and direct expenses in the amount of $213.50 on or before January 1, 2021 to the State Bar of Texas. Second, he failed to pay restitution in monthly installments of $1,200 due the first of each month, with the first payment due on January the 1st, 2021, and continuing until he had paid the full amount of restitution. Third, he failed to timely complete 12 hours of additional continuing legal education, 4 hours each in the areas of probate law, law office management, and ethics. These 12 hours were to be completed between February 1st, 2021 and January the 31st, 2022. He also failed to make contact with the Chief Disciplinary Counsel's Office, Compliance Monitor, and Special Program Coordinator not later than 7 days after receiving a copy of the judgment to coordinate his compliance. At this time, I would offer petitioner's exhibit number 1, which is a certified copy of the agreed judgment of partially probated suspension entered in case number 2019-01592, dated October the 6th, 2020. Exhibit 2 is a business records affidavit affidavit of Heather White, compliance monitor, with the documents regarding his compliance. Exhibit 3 is a certified copy of an agreed judgment of probated suspension entered in cause number 2021-01469, dated November the 30th, 2021. And Exhibit 4 is the original certificate of Blake and Hawthorne, clerk of the Supreme Court of Texas, dated April the 10th, 2023, indicating that the respondent is licensed and currently authorized to practice law in the state of Texas. I'd like to have those admitted at this time.
You're muted.
Exhibits 1 through 4 are admitted. Thank you.
Thank you. We respectfully request an entry of judgment revoking probation and actively suspending the respondent from the practice of law for 5 years. At this time, I would call Heather White.
Ms. White, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Could you state your full name for the record, please, Ms. White?
Heather White.
And who do you work for?
I work for the State Bar of Texas Office of the Chief Disciplinary Counsel
And how long have you been employed by our office?
since June 4th, 2012.
And what's your current title?
I'm the statewide compliance monitor.
Would you briefly describe your job duties to the panel?
Yes, as the compliance monitor, I monitor a respondent's compliance with their judgment terms, which may include restitution, attorney's fees, affidavits, law license and state bar card submissions, also mental health and rehabilitative terms, IOLTA terms, and I also monitor suspension dates and reinstatements.
Thank you. Are you familiar with case number 2019-01592, style the Commission for Lawyer Discipline versus Paul Jason Brower?
Yes,
And did you monitor that judgment file, or are you still monitoring it?
I am.
Do you have a copy of our exhibit number 1, which is the judgment of in that cause?
Yes, I do.
This is a judgment of partially probated suspension.
Yes.
And what are the dates of the respondent suspension?
Mr. Brower, this is a 5-year suspension with an active suspension from the dates of November 1st, 2020, and then ending January 31st, 2021, with a probated suspension beginning February 1st, 2021, and ending October 31st, 2025.
What were the terms and conditions of the active suspension?
So Mr. Brower was required to contact the compliance monitor within 7 days of receipt of a copy of the judgment. He was also required to notify all current clients and opposing counsel and return any client property by November 1st, 2020. He was also required to notify all judges and courts of the terms of his suspension by November 1st, 2020, and file affidavits stating that he did all these things. And he was also required to surrender his law license and state bar card by November 1st, 2020.
Okay, did he comply with those terms?
Yes, he did.
Did he comply timely with those terms?
They were received on December 23rd, 2020, and I heard from him on November 10th, 2020.
That was past the time that they were due.
Yes,
So at the end of January 2021, he placed on the probated portion of his suspension.
yes, he was.
And what were the terms of the probated suspension?
So he was supposed to pay restitution. He was supposed to pay a restitution to Delbert Purdy Trust in the amount of $57,580.09 in monthly installments of $1,200 beginning January 1st, 2021 until paid in full. He was required to pay attorney's fees in the amount of $300 and expenses in the amount of $213.50 by January 1st, 2021. He was required to complete an additional 12 hours of CLE by January 31st, 2022, and also contact the compliance monitor by October 23rd, 2020.
Okay. And how much has Mr. Brower paid in restitution?
He has not paid any amount of restitution.
How much has he paid towards attorney's fees and expenses?
He has not paid any amount of attorney's fees or expenses.
And did he complete the additional hours of CLE?
Yes, but he submitted proof late,
When did he actually submit the proof?
April 17th, 2023.
Sorry to interrupt, but did he complete them on time? Complete the CLE hours on time and he just submitted the proof late, or did he not complete the courses on time?
It was kind of a mixed bag. Some courses were completed timely and some weren't, but we had asked him for proof of completion many times, but we just got it in April.
That was after we filed the motion to revoke that we finally got that.
Correct.
Did he contact you by October the 23rd, 2020?
No, I didn't hear from him until after he received our introductory letter. So he had responded to my email to him on November 10th, 2020.
And how have you attempted to gain Mr. Brower's compliance? And if you need to look at Exhibit 2, I think that's been filed already with vote and it's been admitted as an exhibit.
Yes, but
Kind of briefly tell some of the efforts you made to gain compliance from Mr. Brower.
sure, yes. The compliance team initially started off sending an introductory letter to Mr. Brower on November 10th, 2020, which he did respond to the next day. We also sent him 2 subsequent demand letters for several of the items that he was not in compliance with. And we sent him many emails, and I also spoke to him on the phone several times.
Okay, were there any attempts to work out a different payment plan with Mr. Brower during that time?
Yes, on several occasions, he did promise payment. And when we didn't get it, I offered to work on an amended payment plan with him. And we got one in writing and he still didn't comply.
We still made no payments at all?
No.
Ms. White, I'm sorry to interrupt again, Mr. Berry, but the last correspondence we saw on the payment issue was November 2nd. He sent you a proposed plan of 2021, and then you responded back November 3, 2021 and said, I just talked to Will and he's going to call you to discuss altering the plan a bit. Is there any subsequent correspondence where there was an agreed to plan or he was informed about what the new requirements were going to be?
Yes, and that happened over the phone. So the new plan was for him to pay the restitution that was owed in his other judgment to a person with the last name of Kapsner. And then to resume payments for the trust right after. And so what we did was we just verbally altered the dates a little bit, but he didn't comply with that either. He is in compliance with the other judgment, though.
Okay, thank you.
Sure.
Those are all the questions I have, so I would rest at this time.
Any other questions from the board?
Ms. White, did he give you any indication on why financially he was not paying? Was he unable to, or just not doing it?
Yeah, he was struggling. So this judgment was executed during the pandemic, and he's living in LA, and he was on lockdown and lost his job. And I believe there were several other factors going on. I think his wife was sick. And I know he's just struggled with employment here and there. And but he did at one point tell me that he was receiving COVID emergency funds, and he was going to send in a good faith payment with that money, but we never received it.
How much was the good faith payment going to be?
He never specified. He said he was waiting for the funds to come in and that he would let me know.
You know anything about his assets or ability to pay, or do you all even get into that with them?
No, I don't know.
Thank you.
Sure.
What was the last conversation you had with him, Ms. White, about his compliance?
That was just recently. So he sent in one last email. Let me pull it up. So he sent in one last email after we filed this petition for revocation on April 17th. And he was hoping to do another amended payment plan. And he said, I can read it to you. Do you want me to read it to you?
Yes, is it included in what you've submitted or no?
I'm actually not sure.
Okay, if you could
Because I think it came in after, so I'm not sure. I'll read it.
okay.
Okay, Heather, as per conversation, I am attaching my MCLE transcript. I was unable, okay, so it might be in there. I was unable to find a copy of the unlawful detainer eviction pleading, but it was case number 22 IWD 00946 in Los Angeles County Superior Court entitled Benrock versus Paul Jason Brower. As I stated in our conversation, I'm currently not able to make the monthly payment as initially agreed, but I do have a good job now, and I'm currently registered to take the California bar in July. If I'm able to take the bar, I have been guaranteed an increase in salary that will allow me to make the monthly payments and to get the judgment paid off. However, I have to be in good standing with the Texas bar to take the California bar. Therefore, if there is any way we can reschedule the payments to a more graduated scale, then I can begin making minimal payments now to show compliance. And then once I am licensed and practicing again, I will be able to up those payments and get the judgment current. If I need to attend the hearing to accomplish this, I would be very happy to do so. However, as you are no doubt aware, funds are extremely tight right now, and I do not currently have the ability to attend in person. I am more than willing to appear via Zoom, but I would prefer to attend in person. While I do not have any vacation days this month to use for the trip, I was already scheduled to be in Texas the week of May 22nd. So if I can appear in person, I was hoping that I could get a continuance to next month so that I can attend in person in May. I appreciate the help you have provided, and I am very determined to get this outstanding debt paid. Since the eviction and period of being unhoused, I worked diligently to get back on track, including, and then he lists several things, obtained an increase in salary, negotiated a reduced rent living arrangement that will allow me to financially recover, obtained health insurance, and began seeing a mental health professional to address the issues that lead to these and the grievance-related issues, including my mother's death and my wife's lengthy illness. Registered with the California Bar to take the exam in July, obtained classes to study for the California Attorney Bar through my current employment, maintained my $1,250 a month child support payment, reduced living expenses by moving closer to my job and only having one car for me and my wife, worked a second job at night to supplement my salary. I understand that I have not been giving you or the board much reason to trust me in the past, but I am in a far better place than I have ever been since this proceeding began, and I am right on the cusp of being able to get this debt paid. If I need to add months to my suspension, I am willing to do that. I just need a few more months so that I can take the bar and get these payments current. In the meantime, if I need to make weekly payments to show that I am serious about compliance, I am happy to do that. It is my intention, as always, to fully remedy this amount owed. I just need 3 more months to allow me to make the bar exam here.
Thank you. And when was that?
That
What was the
was April 17th.
Of 2023?
Yes.
Did you respond to that email or have you talked to him since then?
We talked on the phone shortly after that. And I told him that any continuance that he wanted to, like if he wanted to continue this hearing, he needed to talk to Judith or file a continuance. We also discussed that it may be unlikely for him to get licensed at the bar in California because he would not be able to get a certificate of good standing out of Texas, being on disciplinary suspension at this time. And, you know, he was pretty disappointed. So I was pleased that he had filed this continuance and that it was granted. And I'm kind of surprised that he's not here today.
Thank you. Any other questions from the board? Mr. Barry, do you have any further questions?
I do not.
Any further remarks?
I would just say that he's been given ample opportunities to make some kind of good faith payment through this whole process, and he's failed to do so. Even though his MCLE, some of it was completed on time, some of it wasn't, he still didn't submit those hours, even when he had completed on time, until after this motion, until our motion for revocation was filed. I respectfully request that the board enter a judgment revoking his suspension.
All right, thank you. We'll take this under advisement. And that concludes, well, before I conclude, Ms. Truitt, I assume that Mr. Brower hasn't contacted you or tried to dial in at all?
He has not.
Okay, well, then this does conclude today's proceedings before the Board of Disciplinary Appeals. We're adjourned. Ms. Truitt, if you can let Mr. Barry and Ms. White out of the main room and Ms. Bowen, then the rest of us can confer.
Thank you all very much.